The U.S. Supreme Court has decided not to decide the broad issue of whether electoral maps should be allowed to give what some consider an unfair advantage to a political party. But justices did rule in a pair of state-specific cases. Correspondent Doug McElway looks at what all this means.
The High Court took a pass on two gerrymandering cases today, one from Wisconsin Democrats, the other from Maryland Republicans that challenged redrawn congressional and legislative districts. The Maryland case appeared to be a clear-cut case of gerrymandering or reshaping a district to benefit one party. Its rural 6th district had been represented by Republican Roscoe Bartlett for more than 20 years. But after the 2010 census, Maryland's Democratic legislature and then Democratic Governor Martin O'Malley reworked it to include heavily Democratic areas. It worked.
In 2010, Roscoe Bartlett won by 28 points. In 2012, after the gerrymander, he lost by 21 points.
In a deposition, O'Malley admitted, quote, "It was my intent to create a district where the people would be more likely to elect a Democrat than a Republican." But in today's opinion, the High Court dismissed the Republican argument on narrow grounds. Quote, "A court must consider whether the movement has shown that he is likely to suffer irreparable harm in the absence of preliminary relief." The plaintiffs made no such showing.
Hasta la vista to gerrymandering.
In the Wisconsin case, it was Democrats who filed suit, complaining the Republican-controlled legislature redrew congressional districts to favor GOP candidates. But in his majority opinion, Chief Justice John Roberts rejected the Democrats' argument, ruling the plaintiffs, quote, "never followed up with the requisite proof that they had standing and a personal stake in the matter."
We were a little bit disappointed that the court did not set a standard for partisan gerrymandering. However, they did leave the door wide open.
Indeed, Chief Justice Roberts noted today, quote, "We leave for another day consideration of other possible theories of harm not presented here." And that suggests that the court may retake up the broader question of setting limits to gerrymandering in its next session when it takes up a North Carolina case. And that can mean clear nationwide guidance on just how far is too far, with voter maps set to be redrawn after the 2020 census. Brett?
Doug McElway outside the U.S. Supreme Court. Doug, thanks.